Are you looking to up your real estate investing game? Well, you're in the right place. Welcome to the Sub 2 Deals Show with your host, Sub 2 expert William Tingle.
Hey, Sub-Tours, this is William Tingle with Sub2Deals.com. I want to welcome you to this episode of the Sub 2 Deals Show. Today's topic is land trusts. For some reason, the last couple of weeks, there's been a lot of discussion about land trusts, what they are, how do we use them, just all kinds of questions. So land trusts seem to be a little bit hard for the average person to understand, and I can certainly understand that. I remember when I first learned about land trust and how great they were and everything, and I can remember the process seemed just so complicated. I remember laying all the different forms out on the floor and saying, okay, this one's first, and just shuffling them around and that sort of thing, just really trying to understand how they worked. But as of today, 20 years later, I've bought over 500 different properties, and I can tell you that virtually every one of them have been bought inside of a trust. And I just think they're great, and we'll go over the reasons why. Let me start this by saying I am not a lawyer. If you didn't know that, now you do. I am not a lawyer. And even though we're going to be discussing law to some extent here today, as with everything else, please be advised by an attorney that you trust on this subject. If you can find one there locally that understands land trust, great, because it's hard to do. But if you can find one that understands, have a long conversation with them and know exactly what you're dealing with. Number two, I am not a trust expert. I have used trust in 7 states where I've been party to investing in real estate, but that leaves 43 where I know little to nothing about how it works. So if you want an expert in your state, again, consult an estate planning lawyer. Hopefully you can find one that understands land trust and they can help you with what you need. Okay? But I'm going to tell you what I know about them today and why I think they're great. So let's start with just a little bit of history about a land trust. Well, history tells us that during the time of Henry VIII, ownership of property by regular citizens, just like you and me, was considered somewhat of a liability. If you owned land in your name, you had 2 major obligations. One was to pay taxes to the king, and 2 was to serve in the king's army. Now, not everybody wanted to do those things, a lot like today. And people realized that by hiding their ownership, they could avoid these things. So they would transfer title to a friend or family member who maybe lived out of the country, and that would remove their name from public records. Of course, as with any good thing, eventually the people in charge found out. And when the king found out what was really going on, he was kind of upset. And he enacted something called the Statute of Usage, which basically outlawed the whole trust deal. Okay, he said, you can't do it. I don't appreciate it. You're trying to get out of paying me my money and serving in the army. So we're just going to stop it. But sometime later, the English courts modified his ruling to make it so that the use of a trust was valid, as long as the trustee actually had some duties and was not just a mere title holder. It wasn't really just a farce. If the trustee actually had some responsibilities and things that he did, then it would be okay. Now, the common law system found in the United States today is based on only English law. So when you have a state that does not have specific statute law regarding trust, common law will generally apply. That is how it is today that land trusts are able to be used in pretty much every state. Now, there's no law in any state that makes the use of a land trust illegal. While there are a few states that have requirements that make using them really what I call not worth the trouble. Okay, and there are some states that do that. You either have to disclose the beneficial interest or register your trust or all kinds of other things. And in those cases, it may not be worthwhile to really use them. There's not much benefit in it. But what you need to remember is that if a court ever determines your trust is invalid, there's no fine or jail time. The title will simply be looked at as vested in the name of the beneficiaries. So it's really just like you never used one. It's not that big a deal. So now that we know a little bit about the history of the land trust, I want to talk to you a little bit about what I think the advantages are. And of course, number one is privacy. Most people go out and they buy real estate and they've got their name all over the place. All it takes is a search of the public records. And it's so easy now with the internet. You can go into a tax assessor or tax collector website, type in Joe Smith's name, and bam, you know everything that he owns in seconds. But with a land trust, you have privacy. The title is going to be held in the trustee's name, and depending on how you actually write your deed out, it may be listed in the public records by the trust name first. So the trustee's name may not even show up. But privacy is the number one benefit. Now, what does privacy allow you to do? Well, it lets you do some pretty cool things like, number one, you can be the good guy with tenants. When I first got started buying real estate, I'm sure a lot of you people are the same way. You were proud of the fact that you were a property owner and you didn't mind who knew that. Well, what I learned was when you're the man, you got a really big target on your back. You come out a lot better if, for all purposes, the tenant or your buyer, if you're dealing with them directly, they think you're just part of the management team. Okay. I can't tell you the number of times that I've gone to visit a tenant for whatever reason, and maybe they had a dog and they weren't supposed to according to their lease, and I was able to say, "Hey, Joe, I see you got a puppy there. Man, I hope, the owner doesn't find out about that." And, "Oh, man, you wouldn't tell them, would you?" I said, "Well, I have a responsibility to do that, but I'll see what I can do for you." Now, of course, the owner never would agree to that sort of thing, and I would have to go back with the bad news. But being able to be the good guy really makes your job a lot easier. The second benefit of privacy is, let's say in the case of a lawsuit, somebody wants to sue you. Maybe your tenant slips and falls and runs downtown to see the ambulance chasing attorney, and they do a quick search online and see that, hey, Joe Smith owns a lot of property. Well, there's probably a settlement to be had there. I think I'll go ahead and sue him on a contingent basis. But what if he looks up Joe Smith's name and there's nothing to be found? There's no guarantee that Joe Smith even owns that property. So that's probably not a case that he would be willing to take. So maybe it helps you with avoiding lawsuits. Your ownership not being on public record just really has a lot of advantages. So the privacy is really the big advantage to me. Number two, the due on sale clause. Hey, if you're a subtuer, that's a big deal. You want to take title in the name of a trust, if it helps you avoid the due on sale clause, which really isn't that big a threat anyway. But I'll take any help I can get, and if that's one of the things that maybe gives me a hand with avoiding that, hey, I'm all for it. According to the due on sale clause, one of the outs that the homeowner has is transferring title into a trust, for their benefit. And if the lender assumes the transfer was for the homeowner's benefit, that's fine. They can assume that. I won't tell them any different, but that's one of the advantages. Number three, asset protection. A trust can pretty much make you judgment proof with regard to, someone getting a lawsuit against you and filing that on public record. If every property that you own is in a separate trust and that judgment is against that particular property, well, guess what? That one may be tied up. But if you want to refinance or sell or do anything else with the rest of your properties, you can do it without having to satisfy that judgment today. And that's a really big advantage. Number four, ease of transfer. A simple assignment of beneficial interest that doesn't even need to be notarized unless the trust agreement calls for it is all it takes to transfer the interest in a property. So if you're able to sell that property to another investor who is trust savvy, it's really simple to do. You have the convenience of multiple ownership interest in the property. If a partnership owns it, it can be inconvenient for all the partners to notarize signatures if that's needed. And with a trust, it only requires a single signature from the trustee. Some other benefits include avoiding probate. If you have a large estate, most probate attorneys are paid a percentage of the value of the estate. And if a property's in a trust, the trust document itself can designate who would be the beneficial interest should the original beneficial interest of the trust pass away. So that can already all be settled. You can avoid transfer tax in a lot of states. A lot of states, you can, when your property goes from your seller to the trust, there will not have to be a transfer tax document filed and no fees paid. And another big advantage that I discovered uh, doing rehabs on property and selling retail was the FHA seasoning rules. I remember when the rules changed and you had to own a property for at least 6 months to sell it for your buyer to be able to get an FHA loan. What we learned was transfer into a trust seemed to avoid that seasoning problem. We sold numerous properties within just 2 or 3 months to FHA buyers, and there was never anything mentioned about seasoning. So, just some of the advantages of using a trust.
The Sub 2 Deals Show with your host, Sub 2 expert William Tingle. We'll be right back. Hey Sub-Tours, have you been trying to learn how to invest in real estate? It can take you years to learn the ropes on your own. How many people do you know who have been looking into real estate investing for years, but have never bought a single house? Do you have shelves full of courses but lack the courage to get out there and close on that first deal? Are you tired of so-called coaches who always seem to have just one more thing to sell you that you absolutely must have to be successful? Are you tired of trying to piece it all together with YouTube videos and free forms found on the internet? Is that really any way to build a business? William Tingle has been coaching real estate investors all over the country for over 16 years. And if you are ready, he can show you how to buy all the houses you want, anywhere you want, without ever having to ask a banker for one thin dime. Contact William today at sub2deals.com and schedule your free 30-minute strategy session. Talk it over, and if you think you're finally ready for success, he'll get you going. Back to the show, the Sub 2 Deals Show, with your host, Sub 2 expert William Tingle.
Now, I've gotten a lot of questions the last couple of weeks. I want to try to answer those. Who can be a trustee? Well, pretty much anyone or even an entity can be a trustee for you. You or your spouse could be an entity. Of course, you probably wouldn't want to do that if you're counting on the privacy issue. A trust department at a bank, you could always get somebody at your bank to do that. The only problem I see with that might be fees that they would charge, or the fact that they might not want to do everything that you want them to do. Most of the people at the bank are pretty conservative, and they have some unusual ideas about what's legal and what's not legal. Trust companies, some title companies also perform as trust companies, and they can do it. But again, the same problems you'd run into probably with a bank. A closely held corporation, which is, of course, your own corporation that you use as a trustee. We used to do that. That used to be the primary thing that we did in Georgia. We used our own corporation to be our trustee. An attorney, obviously, your attorney would make a great trustee. Most of them, especially if they're an attorney for a creative real estate investor, they're already kind of out there, so they know that you do some things that aren't really common, and they would probably be a good trustee for you. A relative or friend living out of state is considered ideal, especially if they have a different last name. They would be hard to reach if anyone were trying to serve papers or file any sort of lawsuit or anything like that. The further away the trustee resides, the more difficult it would be for outsiders. Okay, the only way a trustee should reveal the identity of the beneficiaries is by court order. And keep in mind that a court order is only valid in the state in which it's issued. If your trustee resides in another state, it will make it much more difficult for an attorney trying to serve process, as I said. So your ideals would probably be an attorney or a close friend or relative who lives out of state. Another question we got was, what are the trustee's responsibilities to the beneficial interest? Well, a trustee's duties and obligations arise out of two sources: the trust agreement and general trust law principles. Under general trust law principles, a trustee has a fiduciary responsibility to the beneficiaries, which basically means that their job is to act in the beneficiary's best interests. As far as anything else they're responsible for, that would be specific to the trust agreement, and you can modify those to accommodate whatever you're looking for specifically. Another question is, can the trustee be held liable? Well, generally, a trustee is not liable to third parties for acts completed within the scope of their duties as trustee. So as long as the trustee discloses his capacity, then chances are he wouldn't have anything to worry about with that regard. Most states have laws that protect a trustee from personal liability. And along with that, a trustee should always sign all documents related to the trust and the property with his name as trustee and not personally of the trust name above. All parties dealing with said trustee should look solely to the assets of the trust. And my recommendation is to have a rubber stamp made that says that, because that can get pretty tedious writing that. Who can be a beneficial interest? Well, a beneficial interest can be one or many. A person, a living trust, a corporation, an LLC, a general partnership, or any combination. The ownership in the trust can be divided up in any way. They can also specify what should happen to the property upon death. Remember, we talked earlier about avoiding probate and how to do this. A good way to handle this is to have the beneficial interest of the trust be a living trust. Then the living trust, not the actual land trust, can specify what happens with regarding if the beneficial interest passes away. So that could be even kept out of the trust document if it were in the living trust. What are some of the disadvantages of a land trust? Well, the biggest one is probably going to be just the general lack of knowledge among even banks, realtors, agents, title companies, attorneys. You'd be amazed at the number of times I've been told that a trust is illegal. And I mean, told that by lawyers. It's incredible. What I went through to find my first lawyer that could really, had a grip on this stuff and could really take care of it, I was amazed. But you would think these guys would know, but they don't. And that's another one of the advantages in the states that there isn't statute law, which is just legislation that's been passed by the government body in the state. If there's not statute law and it's relied on by common law as far as ruling on the trust in certain states, there's just not a lot of knowledge regarding it. So most of these guys don't know how to deal with people that use trusts, so it protects you from that aspect, but it does make it harder to find people that can work with you and work with your trust. Number two on the disadvantages is the paperwork. It does involve some paperwork, and if you're not a detail person and not one to take care of those things, it can be a little bit of a pain. But generally what I find is if you do all the paperwork on your buy or on your sell and get it all out of the way, then it's pretty much taken care of until you sell the property. Number three would be lenders and refinancing. If you own property in a trust and for whatever reason you decide you want to refinance it, it's pretty difficult to get a traditional lender to let you leave that property in a trust. Now, buying subject to and using a trust is perfect with regard to the privacy issue, because the property goes straight from your seller to your trust. Your name is never mentioned anywhere. But if for some reason you decide to refinance one of these properties and then you have to take it out of your name, or excuse me, out of the trust name and put it into your name and then put it back into the trust name after the refinance, your anonymity is pretty much shot right there. So refinance on some of these can be difficult. Number four, loss of homestead exemption. That's generally not going to be a problem for most investors anyway, as this won't be a homestead property for them. But let's say that you wanted to put your personal property into a trust. Some states have an issue with that, and you would lose your homestead exemption. Number five, possible problems with the trustee. We've never encountered this, but I can see where it could potentially be an issue, especially if you had appointed, say, an in-law as your trustee and then something happened or that sort of thing. So you really need to be careful in who you're choosing as your trustee. And lastly, statute of uses problems. Remember, we talked about Henry and his law with statute of uses. In states where there are no specific statutes regarding land trust and you rely on common law, the court may rule against the validity of your trust. And that's always a possibility. Okay. So really, the disadvantages, most of them are pretty remote. And I mean, for me, the advantages to using a trust far outweigh the disadvantages. Anyway, a land trust used in conjunction with entities is an incredible asset protection tool, I believe. You've got your entity to actually protect you from liability. You've got your trust there to give you some anonymity and some other advantages. And I just really can't imagine not using them. In most cases, if you've got a trust document that applies in your state, all you have to do is change the names and the players every time you buy a property, and the only actual document that gets filed is the deed anyway. And you're going to file a deed anyhow. The trust document's going to go in your file drawer, in your file cabinet, and no one's ever going to see it. So really, that's kind of it on a land trust and how it works. Of course, if you have any questions, you can always contact me on our Facebook group or at sub2deals.com. You can email me at william@sub2deals.com. And I've also, in the show notes here, I'll have a link to an excellent trust course that actually is how I learned how to use land trust. So that's it for land trust. I hope this was helpful for you. And get out there and buy some houses.
Thanks so much for listening to this episode of the Sub2 Deals Show with William Tingle. If you enjoyed today's episode, please leave a review and subscribe. And for more great content and to stay up to date, visit sub2deals.com, on Facebook at Sub2Deals. We'll catch you next time.